Okay, this is the motion to suppress certain evidence, so not all the evidence. Comes now, the defendant Travis Hines, pro se, respectfully submits this motion in limine pursuant to the Criminal Code of 703 and 403, the Constitution, with the amendments 1, 4, 5, and 14, and the Louisiana State Constitution, Article 1, Section 2, 3, 4, 5, 6, 7, and 13. And for the reasons set forth in the following memorandum to suppress evidence and statements, and hereby moves that the court enter an order. Memorandum, factual background. On January 22nd, 2022, at approximately 12:30, Mr. Hines was utilizing taxpayer-funded services of the Natchitoches Public Library, a public space on the second floor of the library and separate magazine room with a single entrance exit. Mr. Hines had just arrived at the library and was setting up his cameras and laptop computer at a table in the magazine room. Described. A library employee contacted the Natchitoches Police Dispatch requesting officers check on a man who, in employee's words, was being really weird. Tried to go up to the third floor, check the emergency exits, and stuff like that. He's being really weird. Responding Officer Favors entered the magazine room first and immediately followed by Officer Davis, where Mr. Hines was located. Officer Favors, having entered the room first, would have been able to see Mr. Hines in his computer prior to Officer Davis. The officers placed themselves between Mr. Hines and the only exit from the room. Officer Davis informed Mr. Hines that police received a call about someone matching Mr. Hines' description who was kinda acting suspiciously. Mr. Hines asked Officer Davis what the exact complaint was, and was specifically what the suspicious nature or behavior that Officer Davis was referring to. Officer Davis stated that he was not sure and that he was responding to the call. Officer Davis then asked, "What's your name, boss?" and verbally directed Mr. Hines' movement. Officer Davis then began questioning Mr. Hines, asking him his name and to produce personal documents, at which point Officer Miller entered the room, placing himself next to Officer Davis and in between Mr. Hines and the exit. Mr. Hines explained that he had came in to use the public library and asked Officer Davis, "Is it unusual that people use the library?" Officer Davis responded, "No." Mr. Hines again asked officers what was their exact suspicion to make contact with him. Mr. Hines continued to explain his reason for his presence and actions in the library in an attempt to dispel the concerns officers had. Hines stated, "What I did is I came in, I walked around, looked around, I've never been here before." Officer Davis then told Mr. Hines to stop talking and asked, "What's your name?" Mr. Hines retorted, "Well, what's the crime?" Officer Davis responded, "We have a report of a suspicious person matching you," meaning we have a reason to talk to you. "And right now I'm asking you what your name is, and if you don't provide me with some sort of identification, that is resisting an officer." Mr. Hines responded, "No, it's not. How are you going to go above my constitutional protections on this? Because there's no crime." Officer Miller then directed his subordinate officers to stop speaking to Mr. Hines as Officer Miller took over the questioning of Mr. Hines. Officer Miller stated, "So this is how we are going to do this." Officer Miller again describes that police were responding to a suspicious person and that Mr. Hines matched the description of the person reported to police. Officer Miller then asked Mr. Hines to produce personal documents without stating any reasonable suspicion or probable cause of any law violation. Mr. Hines informed the three officers there was no crime, which clearly agitated Officer Miller, who immediately and physically seized Mr. Hines while verbally stating to Mr. Hines that he was under arrest. Officer Davis physically assisted Officer Miller by restraining Mr. Hines' left arm and helping Officer Miller handcuff Mr. Hines. Mr. Hines continued to advise all officers of his Fourth Amendment right under the Constitution to be secured in his personal papers and effects without being charged with a crime. In a report dated January 22nd, written by Officer Davis in association to the arrest of Mr. Hines, Officer Davis stated, "When I made initial contact with the subject, he pulled up a digital pornographic image onto his computer screen. The image was a white website page with an orange banner on the top that depicted the bare posterior of two women at the top of the page on either side of the orange banner. The image on the right side of the orange banner was the bare posterior of a woman, showing the woman's exposed anal and vaginal opening. However, the image on the left depicted the vagina of the woman on the left being penetrated by a penis. Both images were in motion." Officer Davis makes no mention of his reported observation in support of Mr. Hines' arrest and does not charge Mr. Hines with any crime. Legal framework. No charges related to what Officer Davis alleges in his report were filed. Absolutely no questioning, discussion, or conversation in the library about this statement was made. Officer Davis does not make mention about his alleged allegations to Mr. Hines at any time prior to arresting him. Officer Davis does not notify his supervisor, Officer Miller, about his reported observation. The statements in Officer Davis's report would not constitute a crime if they were substantiated. The City of Natchitoches prosecution's position on this matter, as stated in open court on February 15th, is that Mr. Hines was immediately seized in some unarticulated capacity when officers made mere contact with Mr. Hines. A seizure is an arrest if a reasonable person in the suspect's position would have understood the situation to constitute a restraint on freedom of movement of the degree which the law associates with formal arrest. The City of Natchitoches contends that either by investigatory detainment or legal detainment, both which would have required that the police officers first possessed reasonable articulable suspicion of the specific crime supported by facts in accordance with Terry v. Ohio, or that the officers had decided prior to the contact with Mr. Hines based upon probable cause that they were going to arrest Mr. Hines. Officers failed to produce this authority through any lawful means. Reasonable suspicion must be based on the facts of a particular situation, not an individual's hunch. While officers are free to demand identification in the circumstances of a lawful stop or arrest, they may not arrest a suspect for failure to identify himself if their request for identification is not reasonably related to the circumstances justifying the stop. In Hibble v. 6th District Judicial Court. According to the officers, they had probable cause to arrest Mr. Hines for failing to provide identification, an alleged violation of Louisiana Revised Statute 14108. This statute requires an arrested or detained person to provide identification only when the officer is making a lawful arrest or lawful detention. See, nevertheless, in accordance with the City of Natchitoches' position, Mr. Hines is not free to leave once police made contact with him, as he was physically blocked from freedom of unrestrained movement. Mr. Hines' unlawful arrest was immediate and without probable cause. Mr. Hines was then questioned by police about matters that adversely affected him, as made evident by his eventual unlawful arrest. Under the Fourth Amendment, police officers may not require identification absent an otherwise lawful detention or arrest based on reasonable suspicion or probable cause. See Brown v. Texas in 1979. Under both Louisiana law and the Constitution, Mr. Hines was required to provide identification only if he was otherwise lawfully detained. The officers would have no probable cause to arrest, as the request for identification came during an illegal seizure. The officers could not have had probable cause to arrest, and the verdict cannot in law be supported by the evidence. See a couple of cases criminalizing the refusal to provide identification in the context of lawful stops or arrests. Mr. Hines verbally challenged the actions of police officers by telling them that the law as Officer Davis represented, it was incorrect. This clearly upset Officer Davis and Officer Miller, who stated to Mr. Hines, "So this is how we're going to do this," and continued on describing to Mr. Hines the call for service, identifying a suspicious person. When Officer Miller again asked Mr. Hines to identify himself, Mr. Hines stated, "There is no crime." Officer Miller, who had been verbally challenged by Mr. Hines' expressive disorder, immediately made the arrest. Mr. Hines' speech and verbal challenges were protected under the First Amendment of the United States Constitution, as the First Amendment requires that officers and municipalities respond with restraint in the face of verbal challenges to police action. In Johnson v. Thibodeau, the court observed, "Defendant has been placed under arrest the moment he refused to produce his identification papers. This action was not authorized by Article 215.1, and in fact, Louisiana law nowhere authorizes an arrest based upon less than probable cause." See New York courts interpreting the stop and frisk statute, after which our own was modeled, have similarly held that an arrest cannot be founded upon an accused's refusal to furnish his identification. And then there's some court cases. While it may be true that there was no reason why the defendant should not have answered the trooper's questions, it equally is true that his failure to answer cannot constitute a criminal act. The court stated in People v. Bambino, this right, however, to detain and investigate on suspicion does not, under any circumstances, and cannot, within recognized constitutional controls, ever justify an arrest on suspicion. While Officer Davis and Miller may have justifiably been angered by Mr. Hines' affront to their authority, this alone could not have elevated a reasonable suspicion of criminal activity to probable cause to believe that a crime had been, was being, or about to be committed so as to justify an arrest. All evidence obtained by searches and seizures in violation of the Constitution by that same authority is inadmissible in the state court. Mr. Hines was ultimately arrested for not producing his personal documents when requested by officers and charged with statute 14108 B1C. However, at no time while he was under detainment or arrest in the library while being subjected to questioning was Mr. Hines informed of his Miranda advisement as required by law when a suspect is under detainment or arrest as contended by the prosecution and confined and not free to leave as made evident by police actions at the library, and is subjected to questions or interrogations without legal counsel present, as made clear by Officer Davis' police report on arresting Mr. Hines for not producing documentation. Miranda v. Arizona, 1966. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The Fourth Amendment protections are incorporated into the 14th Amendment by Wolf v. Colorado in 1949 and Mapp v. Ohio in 1961. Mr. Hines has constitutionally protected rights that were not afforded to him by agents of the government. Natchitoches police officers Miller, Davis, and Favors had a duty to protect Mr. Hines' constitutional rights and advise him of his rights, which they neglected to do. A seizure without a warrant is unreasonable per se, subject only to a few specifically established and well-delineated exceptions. Katz v. United States, 1967. Any evidence seized pursuant to unlawful stop or unreasonable detention is fruit of the poisonous tree and is therefore inadmissible. Analysis. Officer Davis was wearing a body camera that was recording the entire incident, notably during the time he described in his report. The computer screen that Officer Davis discusses is visible on his body-worn camera video recording. Nothing that Officer Davis describes in his report is depicted on the body-worn video recording. If Officer Davis' observation is in controversy to what his body-worn camera shows or not, the relevancy of the statements should be considered as to any probative merits they have to the charges filed. Officer Davis had the opportunity to secure evidence of what he claimed to see, yet he did not. Officer Davis's statements are irrelevant if they could be substantiated and should be excluded as the probative value of his statements are substantially outweighed by the danger of the unfair prejudice of the defendant at trial, pursuant Louisiana Code EV 403. As statements only seek to disgrace the defendant to the trier of fact and are not substantiated by Officer Favor's report or any body camera footage from the officers. The analysis of this issue is governed by the U.S. Supreme Court's long-standing precedent, which provides that law enforcement may not require an individual to provide identification unless the law enforcement officer has reasonable suspicion that criminal activity is afoot. In Delaware v. Bruce, the U.S. Supreme Court held that except in those situations in which there is at least articulable and reasonable suspicion that a person is otherwise subject to seizure for violation of law, detaining a person in order to check his identification is unreasonable under the Fourth Amendment. Here there was no requirement for Mr. Hines to produce identification because there was no evidence that criminal activity was afoot. An investigative detention must be supported by reasonable suspicion. Mr. Hines was not committing a crime at the time of the encounter with law enforcement, nor did law enforcement possess sufficient information to establish a reasonable suspicion of criminal activity. Therefore, Mr. Hines was not required to produce his identification. His refusal to provide information, therefore, should be suppressed. It is true that law enforcement possessed the ability to approach Mr. Hines and request information. However, to the extent that the interaction amounted to only a mere encounter, Mr. Hines could not be required to produce information. In Florida v. Bostic, the United States Supreme Court explained that an encounter will not trigger Fourth Amendment scrutiny unless it loses its consensual nature. In 1991, the Bostic Court recognized that when officers have no basis for suspecting a particular individual, they may generally ask to examine the individual's identification, as long as the police do not convey a message that compliance with their request is required. There is no question that in this case law enforcement conveyed the message that Mr. Hines was required to comply with the request for identification. He was informed that it was a law violation of resisting arrest if he failed to comply. Moreover, he was actually arrested for this reason. Therefore, if the police contacted constituted a mere encounter, the refusal to comply with the request must be suppressed. If the police contact constituted a seizure, in other words, if Mr. Hines was not free to terminate the contact and go about his business, then the refusal must be suppressed because no reasonable suspicion supported the police contact. Either way, the evidence must be suppressed. Finally, it is clear that this incident cannot be justified by law enforcement's community caretaking function. Therefore, the community caretaking exception to the warrant requirements cannot be employed as a mere pretext to permit the state to conduct otherwise unconstitutional investigations. The community caretaking warrant section is narrow. If officers Favors, Davis, and Millers were actually motivated by the desire to conduct a criminal investigation, then the community caretaking exception does not apply. If they were indeed acting in accordance with their community caretaking function, then that function was severed and over when they confirmed that Mr. Hines was not in danger. In either circumstance, the exception has no applicability to the instant issue. Conclusion, whereas and for the foregoing reasons, the defendant respectfully requests this court should grant Mr. Hines' motion to suppress the evidence against him. And then this is the order. It is hereby ordered that any and all statements made by the defendant to any police officer or government agent on January 22nd are hereby suppressed and shall not be introduced as evidence or used in any way pursuant to the 1st, 4th, and 14th Amendment of the U.S. Constitution. Furthermore, all related reference or testimony as to Officer Davis's observations stated in his report as detailed in the attached motion and memorandum are suppressed pursuant to Louisiana Code 403. The attached motion in limine to suppress certain evidence is hereby granted. All right.